Good evening, everybody, and welcome to the fifth edition of the Vidhi Book Adda, a series of curated book discussions on a range of social, political, and legal issues of contemporary relevance. Our book addas typically happen online and are live streamed on our social media platforms, so do watch the recording if you would like to. Today, we're going to be discussing the book, The Law of Desire, Rulings on Sex and Sexuality in India by Madhavi Menon. And I'm very pleased to introduce both our speakers today. First, Professor Madhavi Menon, who is the author of The Law of Desire, Rulings on Sex and Sexuality in India. She is the English professor at Ashoka University and the director of the Center for Studies in Gender and Sexuality, also at Ashoka. I'm also very pleased to introduce to all of you Professor Navneeta Mokil, who will be our discussant today. She is an assistant professor of women's studies at Jawaharlal Nehru University. And this book adda will be moderated by myself, Kanav Narayan Sehgal. I am a program manager at the Vidhi Center for Legal Policy. So thank you to both of you and to all of you who are present for today's book adda. I'm really excited to talk to you about this book. And I think this conversation is happening at a very opportune time in history because almost 30 years ago in 1991, a very interesting document was released by an organization called AIDS Bhedbhav Virodhi Andolan, also called the ABVA, which detailed the discrimination that gay men in India faced. It was a very detailed 70-page report titled Less Than Gay, and it showcased the shocking extent of blackmail, extortion, and violence that gay people in India faced in the hands of the police. We can now fast forward to 2022. We're now in a new decade, new laws, new regulations, new governments, and new conversations about gender and sexuality politics. And I think the question that we should all ask ourselves in this time is whether the law's approach towards thinking about gender and sexuality politics, whether it has changed or not. And if it has changed, to what degree has it changed? How does it view people who possess quote unquote non-normative sexualities and desires? And we have seen very interesting judgments in the past couple of of sexuality in India.
Good evening, Kana. You dropped off for a second there. Could you just repeat the last couple of sentences that you said, because we weren't able to catch you.
Absolutely, thank you so much. So we've seen in the past couple of years many progressive judgments being passed, from the Nalsa judgment to the Puthaswamy judgment to the Navtej judgment, and yet the court has not been able to effectively understand or delineate what constitutes desire and whether there can be one overarching law of desire. And I think, Madhavi, this is a good time for us to start the discussion, because I think in your book, you do mention that it is impossible for the law to frame one holistic kind of law on desire that governs all our lives, given that we do constitute such very different experiences, backgrounds, come from very different social realities. So maybe would like to start this conversation by asking you about this multiplicities, the multiplicities that we possess of caste, of gender, of religion, of desire, and the law's inability to understand this diversity that we all possess. What is it about this that the courts of our country have not been able to grapple with?
Thanks, Kanav. I just want to begin by thanking you and thanking Vidhi. This is very exciting to be having this conversation here, and especially in the company of Navneeta, whose work is so fantastic. And I'm really pleased to be here in conversation with her as well. So thank you, all of you. And I just want to sort of address your question, Kanav, because it's such a huge question, but it's also such a fundamental question. Which is the law capable of recognizing the multiplicity of desire, the sort of hydra-headed monster that desire is? And I want to say at the beginning, in case this was not clear enough from Kanav's introduction, that I'm not a lawyer. And what I'm doing is that I'm interested in the law from the perspective of queer theory, which is what I study, from the perspective of sexuality, and gender, which are my areas of interest. And so if you look at the law not as a sort of legal document whose validity is already given to you, which is how most lawyers sort of approach the law. But if you look at it from the vantage point of sexuality or of desire, then very different cracks appear in the seemingly smooth face of the law. And it's those cracks in which I'm interested, those fault lines in which I'm interested. And one of the fault lines I think that becomes immediately clear is that the law certainly cannot fathom desire, but it is very eager to criminalize it. But when it wants to criminalize desire, that criminalization, the act of criminalization, tends to happen in concert with one of these other terrains that you talked about. So it tends to happen in concert with religion, or it tends to happen in concert with gender, or it tends to happen in concert with caste. It tends to happen in concert with class. And so in some ways, desire becomes almost the universal solvent of criminality. It can be sort of, yoked onto anything that the law wants to suppress and wants to oppress. And I think we see many, many examples, alas, all too many examples of this around us today and over the last few years. And so, yes, I think at one and the same time, the law acknowledges that it cannot take on board all different permutations of desire and sexuality and gender on the one hand, and on the other hand, the way it does that then, or the way it criminalizes sexuality, is to attach it to multiple fields that it wants to criminalize. So there's both a recognition and a forgetting of that by expanding the fields in which desire can be criminalized.
Yeah, thank you so much for that very evocative description. And I think what I found very fascinating in your book, when you talk about, you have actually devoted an entire chapter to criminality. And in that chapter, you also talk about the Hadiya Judgment. Navneet, I want to ask you this because I understand that you've spent a lot of your own time researching queer politics and gender expression in the Kerala context. And you've also looked at the media representation of queerness. We look at judgments like the Hadiya Judgment. And the Hadiya Judgment was a very important judgment because the Supreme Court effectively reversed the Kerala High Court judgment, and it reaffirmed the validity of Hadiya's marriage, although did not really refer to her by her in her real name, Akhila Ashokan. And the media, basically the way in which the media depicted this the entire case, right? It was called the quote unquote, it was depicted as a love jihad case. And Hadiya was basically effectively, there was a form of media trial, which was very, very unfortunate. And the question that I have for you, Navneeta, is if you look at the way in which media narratives around queerness play out today, what do you have to say about the way the law and the way public opinion is shaped by media narrative? Is it correct to say that media narratives shape public discourse, or would you say it's the reverse, where public discourse shapes media narrative and that effectively makes it even more complicated, makes the way we understand sexuality and criminality more complicated?
Yeah. Okay. Thanks, Kanav, for that question, and thanks, Madhavi, for giving me this opportunity, and to Vidhi to engage with your work. And to sort of talk to the question that you are asking, one of the interesting aspects of the book, I think, is that it really zooms in on different kinds of events, right? Like that, that could be sort of gives us a very wide terrain to think about what is desire, right? Like what forms of desire at different points of history get mobilized, get criminalized, and what are the processes through which this interaction between law and desire is constantly getting staged, right? Like, and so if we zoom in particularly on the chapter on criminality, right, like the first opening chapter called Criminal, where one of the central cases that Madhavi looks at is the Hadiya case. Yeah, in that particular case, one could definitely see that there is a certain constant interaction between what we could say is the discourse of the law, like the judgments, the deliberations, and often, as we've seen, like say in the case of 377, like it's not just one judgment, right? Like it's often layering of different there's multiple articulations of the law on the same issue, right? Like, and in the Hadiya case also, you have a particular, position that the High Court is putting forward. Then there is the Supreme Court that's reversing it. But in both cases, you do see that there are certain though there are differences, like as Madhavi also points out, there are certain parallels also, right? Like the fact that marriage, for example, Hadiya's marriage becoming a matter of national concern, right? Like, and almost a national security issue, right? Like, and how that is also mobilizing existing figurations of the Muslim man, like as a terrorist, and also this kind of risk of the Hindu woman who converts, who then, who first converts in Hadiya's case to Islam, and then later marries a Muslim man, right? Like, so that kind of what you say, the progression of events also, right? Like, which one must note, like, and which Madhavi also points out too, that it is different from the what is usually tagged as love jihad, right? Like, because in this particular case, what happens first is the religious conversion, right? Like, and then later the marriage, but a certain kind of conflation of those two events, like both the religious and a matter of marriage and desire, right? Like, comes together in the way the court deliberates on it. But as you rightfully point out, Kanab, it's also how then what is a judgment, what is the deliberation in a court of law becomes public discourse, right? Like, and in many cases, these are happening, I would say, it's very difficult to separate them out, right? Like, what we experience as the public discourse in which we are all living out our own, private lives, public lives, is often through an enmeshing of all these things, right? Like, so how we access the law today is also via media discourses, right? Like, say, think of all the headlines when 377 was read down, or think of the way the media, what photographs will they give, around Hadiya, or what names you use, what language is called upon, right? Like, and there I think there's a lot of constant interaction, right? Like, so we need, in that sense, I think the important intervention that this book is making is also to say that law is very much part of public discourse, right? It's not only about the life of the law and how it affects the particular parties involved, but how it affects all of us, right? Like, how the legal and the is constantly mediating everyday life, right? Like that, that desire is interacting with legal discourses, right? It is changing, positions of is marking out zones of what is natural, what is unnatural, what is prohibited, what is allowed, right? And that is always happening via all these interactions, in which, I think the media does play a huge role, right? Like, whether it's, social media, all kinds of forms of media, right? Like, so yeah, that would be what I would say. Yeah.
Yeah.
I think the public-private discourse is something that I've seen. Also, Madhavi, you've mentioned this very often in your book, and you also talk about this when you speak about prostitution, and also in other cases, the law is unable to demarcate between, when it comes to, for example, questions of obscenity, questions of what is natural, what is unnatural. In your chapter about same-sex marriage, since we're talking about Hadiya and what it was defined as quote unquote an anti-national marriage, you now have the LGBTQ community trying to latch onto marriage to advocate for further rights. And some would say that it is the natural progression for the gay rights movement after the Navtej judgment. But in your book, you have very eloquently critiqued this entire effort to basically try to legalize same-sex marriage. And I understand that this is a position that you also maintained previously. It would be very nice for the audience to also for you to maybe speak to our audience about what you mentioned in that chapter about marriage, the critique of marriage as an institution, and possibly the mistake that gay rights activists could be making in trying to now move towards latching onto marriage to obtain even more rights.
Right. Thanks, Karna. I just want to say in response to Navneeta's wonderfully eloquent answer earlier, that, you know, you're absolutely right. The reason to study the law, especially if you are not a lawyer, is precisely because of the degree to which it impacts our daily lives. And to a degree that we are not even aware of because we don't think about it. And I think the legal system has a lot to answer for that, because it sort of sets the law as being above common people. It sets the law as being the overarching framework rather than the fabric of everyday life. And therefore, you have all these cases of so-called contempt of court, which is, again, such an archaic phenomenon that I wish we would get rid of, but that all sort of fosters the sensibility of the law as being something almost divine. And of course, this sort of divine hedgings of the legal system is very clear, right? Judges are called your lordship, even when they're women. You pray to the court for relief, so on and so forth. And there are huge religious overtones to the so-called sanctity of the law, which is what you offend when you are hauled up for contempt of court. So there is a way in which the legal system works actively to set itself above and apart from daily life, when the truth of the matter is that it is deeply, to use Navneeta's word, enmeshed in what we do every day and in the sort of in our everyday decisions, even when we're not aware of that. And speaking of everyday decisions, marriage seems to be one of those everyday decisions that people seem to make, especially in India, you know, all the time. It seems to be taken for granted as the thing that one will do, as the marker of maturity, as the marker of having arrived in the world, as a marker of financial success, emotional stability, social acceptability. And it is a really powerful force because it sort of at one and the same time assures all these things coming together. Everything that we have defined as the good seems to be attached to the institution of marriage now. And so it is a really powerful institution. The debate around marriage, which alas is not as much of a debate as I hope it will become, but the debate around marriage is that everyone should be allowed the legal right to get married. Now I am, and I want to sort of say there are two portions to my response to this, or to my attitude to this. On the one hand, I absolutely agree that the law should not discriminate against any of its citizens, regardless of sexual orientation. I think sexual orientation cannot be a basis for any kind of discrimination, legal or otherwise, but certainly legal. And so if this is a matter of saying we too want to be recognized by the law as marriageable subjects, then that is something that I can sympathize with and can sort of you know, understand why that is at least coming on board as a request, as a demand. But if the demand is to say that marriage is an institution that grants rights, and therefore we need all those rights, then for me, that is merely repeating the desirability of marriage without holding the law accountable for what it has made marriage out to be. Which is to say, if we want rights, why can we not demand rights unhitched to marriage? Why can we not state the absolute demand to the law that marriage must not be a rights-bearing vehicle? That marriage cannot be the institution that is made to hold all these rights that we deem precious, you know, the right to sort of inheritance, the right to medical care, the right to have children, the right to have a partner on one's insurance. All these rights should be available to everybody as a matter of course, regardless of caste, class, sexuality, and gender, period. To say these rights are currently given by the law only to the institution of marriage, which is true, and therefore we want marriage, is to my mind to completely give the state a free pass and say we will not critique at all your completely absurd freighting of marriage with all these rights that you should be giving to us in any case. So I completely support the demand for equal rights. I do not support the use of marriage as a vehicle for that demand. is the thing that of course, marriage has traditionally been about heterosexuality, and even better, reproductive heterosexuality. And so to sort of say, to privilege that vehicle and say, we want that too, rather than saying we want rights. I think those two things are two separate things, and we need to be able to separate them.
I think the centralizing power of the state seems to be a common theme also in your book. And we're seeing now, especially after the 2014 election, how we're seeing religious majoritarianism and the centralization of power being two concerns that various scholars have raised. And Navneeta, I just want to go to you. Whether we look at laws like the, not laws, but also acts such as the Surrogacy Act, whether we look at the Transgender Act, which was then met with a lot of protests, following which you had the transgender rules, which even that did not completely uphold the Nalsa judgment. You see the state making these decisions time and time again, despite constituents telling them that, hands off our bodies, hands off our desires. Why is it that the state continues to make these very false assumptions about our desires, about sexuality, about gender identity? And how did we get there, where we gave the state so much power? Is this a recent phenomena, or is this something that has been happening for many years, even before our colonial experience, for example?
That's an interesting question. I don't know how much back in history I'll be able to go into, but the question of, let's say, if we think of the history of the post-colonial state in India, and even to some extent the colonial state, and there are ways in which the social body and the sexual as a domain is often a site of governance, right? Like, so if you look at the chapter on prostitution in the book, that chapter also really talks about that. And if you, lots of scholarship around, say, different sort of, different sides of women's bodies, right? Like around reproduction, the mother and child welfare paradigm that the Indian state has, then the whole discourse around AIDS. So there are many, moments of history where you can see this kind of overt modes of governance over different, and there again, like different population categories are sometimes targeted very differently, right? Like, so there are certain groups, let's say, that will be categorized, right, as high-risk categories, for example, in the AIDS discourse, or even with, if you look at the current situation of the pandemic, you see how, again, like in ways of managing disease, and, there's a certain way in which prior conceptions of less, more risky bodies, or less hygienic spaces, or so questions of caste, class, religion, all those kind of hierarchies do enter into. So the state also is not, we're not talking about a faceless entity in that sense, right? It's also how the state then gets mobilized, how it functions, right? Like, and I think in different points of history, it gets operationalized differently, right? Like, but then, when you talk about, like, say, this question that we are raising now, right? Like the whole question of how do we speak about rights, right? Like whether you think about the transgender mobilizations, or, like the demands for rights by gay rights groups, or formations like that. One can also see in a context like that, like ours, I think it's a complicated machinery we are talking about, right? Like, because we are in a context where there are certain there are certain resources, certain demands that we have to place on the state too, right? Like, say, some of the articulations by transgender sex workers during COVID crisis, right? Like, who will get, or even the migrant crisis in the Indian, in Delhi, for example, right? Like, so there again, so I think it is true that we have to be, and different political actors, I think, are aware of that where do you draw the line, right? Like when, how do we make, demands on the states in ways that the state does not have all the power to define you, right? Like, which is, I think, has been the battle around the transgender bill too, right? Like, it's not as if transgender groups are saying that they do not want rights, right? They actually want the state to guarantee certain basic fundamental rights, right to education, right to livelihood, many kind of, what you say, that they should be, that the state has a role in facilitating the growth and well-being of different population groups, right? Like, but that should be, that does not mean that that the state has the power to define who the actual transgender subject is, or who the right kind of woman is, or what is the right kind of unit that will be supported, right? Like, so, like, there again, I think we come back to the marriage question, right? Like, because I think in the opening of the book also, Madhavi, you talk about this, that it's not only about prohibition, right? That the state, the contemporary Indian state, but all forms of nation states actively play a role in also fostering certain relations, right? Like that they give certain benefits. There are benefits that accrue to a particular model of, say, the family. It's not all families there, right? Like, it's a particular model of the conjugality or the heterosexual reproductive unit, right? And which then also makes sure that there are other categories, other living arrangements, which will be marked as not deserving of support, right? Like, which will not get the same kind of facilities or conditions for survival, right? Like, so I think it's a I think it would be risky to say that the state should not intervene in our lives at all, which might in this kind of very neoliberal state formation, currently the state might say, yeah, then go ahead, you take care of yourself, right? But that, I don't think, is the demand that we're making, right? Like, it's also that certain fundamental conditions of livability should be guaranteed, right? It's not just enough if you pass a judgment, but then the question is, how do you live out life, right? Like, is there housing available? If a lesbian couple, from a working class background want to live together, move away from the family, the natal family unit, what kind of conditions are you providing so that they have safe living conditions, right? Like, so there are many, or for a sex worker, is there a home? Is there a residence that she can return to? Are there safe conditions of work that the state can guarantee? So I think there's, like, it's a complicated terrain we are talking about, right? And yeah, I do agree, that it's very important to question this kind of hitching together of these fundamental rights to marriage as the desirable form, right? Because that's already a condition that we're working with, right? Like that, that the state is weighted towards certain forms, right? Like that certain kinds of desires or modes of living have legibility and recognition, while certain others don't, right? And then if a political movement the centrality of marriage, right? Which in the Indian context is already so heavily weighed, right? Not just by, it's somehow, it's not just a question of, like I think Chainika Shah in one of her writings talks about the compulsory marriage, right? Like the marriage as this kind of structure that you have to enter into. So it's not a question of is it desirable or not, but it's almost naturalized as the only condition that can that can gain recognition, right? And that, I think, is something that one should work towards undoing, right? Like, yeah.
Yeah, I mean, I think every time groups of marginalized and oppressed people, and alas, that number is only growing every day in our country. But I think every time groups of marginalized or oppressed people demand rights for themselves, I really think every time they are letting the state off the hook, because these rights should not even need to be demanded, because these rights should accrue to every single person. If we're living within the frame, as you reminded us, Navneeta, of the nation state, the modern nation state, then fine, you can make the cut according to citizenship and say all citizens get these rights regardless. My fear is that the minute we allow our sexual orientation or our gender to form the basis for state intervention, then the state can sort of say, yes, we pick you rather than you. When actually that should not even be a choice that they have. I'm just going to, I was just looking at this, and this, by the way, is what the book looks like. Shall I show that? And one of my epigraphs to this, I have one from, Bulle Shah, one from the Navtej Judgment, and a third one is actually from this American sexologist, Alfred Kinsey. And I've always been struck by this quote of his from the study called Sexual Behavior in the Human Male in 1948. And he says, the fact that there is a body of sex laws which are apart from the laws protecting persons is evidence of their distinct function, namely that of protecting custom. And this is what, we've been talking about, that people conflate custom and persons rather than sort of saying the law actually is interested in perpetuating a certain cycle of, let's call it, reproductive heteronormativity. While it might include other people in that ambit, that is still the custom it is going to perpetuate, right? And of course, one example of that, and I've written about this in the book as well, is the 377 judgment, which, in 2018 was just, and even now it's fantastic. And I'm so, so glad that that judgment happened. There's no question about it. But you see that it happened within very much the narrow parameters of privacy. Privacy, talk about, right, Navneeta, neoliberalism. It is the sort of gilded cage that we're talking about, right? That it seems to promise all this, but it really confines your activities, and especially non-heteronormative sexualities, which often do not have a private space in which to go, to which to repair. This is Virginia Woolf's room of one's own writ large. To then say, if you don't do this in private, then you are criminalized, you're pretty much saying what the law already said. And so this is my concern, that we are so justly celebrating certain legal victories that we don't, in fact, read the fine print, or we don't hold the judges accountable, because, of course, the minute you try and hold judges accountable, you're accused of contempt of court. So you see how this sort of cycle is set up, like the education system in India, to foster non-questioning, to foster people who are just going to say, this is the law. It's like religion. We have elevated it to the level of God, so we must not question it. And I really think, and this goes back to what Navneeta and I was saying early on itself, that unless you recognize how deeply our lives on a daily basis are enmeshed with the law, and unless we then say, wait a minute, surely we have some say over what's going on, and start questioning the law, our condition as a nation, our condition as people, I think is going to continue to go downward.
If we could take this conversation about the public-private dichotomy forward, Navneeta, we've had a conversation about this as well. The Navtej judgment, Madhavi, as you pointed out, it decriminalizes private consensual same-sex activity, and it again seems to operate within the rubric of monogamous relationships. I was recently reading about petitions that relate to the legalization of same-sex marriage, and the government representative argued that the Navtej judgment only relates to the private sphere, not the public sphere. And hence, his argument and his contention was that marriage rights could not be granted because the Navtej judgment is very limited. So, Navneeta, could you talk to us a little bit more about this public-private dichotomy? Is there even a way for us to create a fine distinction between this being in the private sphere, that being in the public sphere? And if we cannot make that distinction, how has the law made that distinction of what constitutes private activity, sexual activity, and what constitutes public sexual activity?
Yeah, I think there are many instances in the book where this question gets addressed, right? Like one of the chapters that I found really interesting was the chapter where you discuss immorality, right? Like that, and in that, like one, the Delhi High Court judgment prior to the Navtej really named privacy more directly, right? And it was, but even much prior to that, if you think about like the legislations around immoral trafficking, right? Like Sita that comes in 1956, and then Ipta, like the later judgment that later act that sort of governs sex work, or prostitution in India. There, I think some of these questions about privacy gets addressed in interesting ways, right? Like, because you're saying that IPTA is saying that it's okay to do the work of prostitution, but there are certain guidelines as to where it is allowed or not, right? Like, so then you are saying that it should not be in public, right? Like, so you shouldn't solicit in public. There are certain regulations as to how it should not come into the public eye, right? Like that it shouldn't be near a school. So there are many. It's one way in which I think sometimes the law or other public, debates around public and private gets played out is that idea of the spatial, right? Like, which is a very important question, I think, because then it also links to the question of who has space, right? Like, who has access to property, who are the kind of, heterosexual or non-normative couples or, people in sexual acts who have access to private spaces, right? Like, so that material question, right? I mean, because many street sex workers, for example, do not have a house of their own to practice their profession, right? Like, so they are often, if you read a book like Nalini Jamila's autobiography, the autobiography of a sex worker, right? Like, many of the instances are also about this precarity of practicing one's profession in public places, like in hotel rooms where a police raid might happen, or in brothels, which is not given any kind of legal status, right? Like, so the precarity of your livelihood is enhanced by the fact that you do not have a space, right, to practice your livelihood, right, or to pursue your own sexual relations, right? Like, so that kind of physical question of this of the public and private, right? But the other, but that's not the only level at which public and private operates, right? Like, there is the whole question of the privacy laws. Like, there's also questions as to, like, say, when is something seen as obscene? Right, like, so some acts, for example, in private, as long, it's almost like as long as you don't see it, it's not obscene, right? Like, but so when things, when what is supposed to be private spills over, right, then things become obscene, right? Like, so this whole discussion around pornography, around censorship is often also around the public and private, right? Like, okay, is the bar dancer dancing in the space of a bar? Is it a semi-public space? If she staged the same dance in a closed room for a single customer, is that okay? If you watch the same dance on screen in a theater, what is public, what is private, right? Like, so I think in many of these, large array of judgments, this whole question of public and private emerges in many different ways, like from the physicality of space to at the level of what visibility in that sense, right? Like, what should or should not be seen, what should, and when what boundaries should be maintained, right? Like, and how, and so even when you recognize certain forms of desire, there is also this idea that it should be managed. There should be certain spaces where it should be housed, right? Like, so for example, like I think there's a lot of discomfort that public cultures around sex produce. Like, say, the figure of, the practices of begging that, hijra communities have been practicing, right? Like, and in how that often creates a lot of discomfort, or even just the presence of a hijra body in public, right? Like, while so what is that discomfort, right? Like, so that is also not about, it is really about, in a public space, certain acts, right, as seen as out of place, as because you want, there's a certain need to maintain certain boundaries, to maintain certain order in public, right? Like, and so there are, and I think many of these judgments do call upon, do create new ways of thinking about the public and private also, right? Like, because again, marriage, I think, has been historically one of, it is it private, is it public? It's very difficult, because it is public in that sense, right? Like, because I could be in a relationship, but the moment I marry, I am making it public, right? Like that if you are registering it, there is a court of law coming in, and then there are many ways that you are also saying what kinds of marriage, for example, can become marriage, right? Like, I think one of the interesting things you talk about, Madhavi, is this Special Marriage Act in the Indian context, right? Like how, and I do know this from my own experience, from the experience of other people, that Special Marriage Act is often much more, there's many more loops to jump through, right? Like, and so in one way you're saying, yeah, it's fine, you can marry across caste, you can marry across religion, but then you have created ways in which it becomes a more, there's more complications, or more negotiations with the state structure, right? Like, so again, seemingly, it is about two individuals, but you do know that it is a public, it is also about the state, it's also about, who can marry who, right? Like, so that line between the public and the private is actually a constantly blurred one, right? And constantly renegotiated. Sometimes, again, like this whole controversy around images, right? Like the Rahena Fatima incident that you talk about, right? Like the mother who allows her children to paint her body. And then the question the court has is that, why did you make it public? Right? Like, why you could have done it, but why did you put it online? Right? Almost around the same time, one of the Malayalam magazines had this picture of a breastfeeding woman, where you could see part of her breast, and she was feeding her daughter. It was a model doing the image. So, but then again, there was a lot of controversy. Like, is this a suitable image? And there, if I remember right, the court said that it was okay. There's nothing obscene about it, like that. It is a breastfeeding mother. It's fine to show her. It does not necessarily offend, right? So again, in many of these questions of what offends, what is obscene, the public-private question, because if you breastfeed in private, that's not seen as obscene, right? Like, or if you bear, so this whole, this divide is. It's not that it's not there, it gets used for different purposes, but it also, there are lots of cracks, right? Like it constantly shifts.
Yeah, and I think that shifting, to go back to Kanav's earlier question about the histories that we've inherited, I think that shifting is very palpable to see as it moves toward, in the direction always of maintaining certain kind of status quo by the state. And if you just sort of think historically back to India, and you have, the Khajuraho temples carved with sculptures of sexual poses, most of which are illegal in India today, was carved in the 11th century in public as a public statement, as a public phenomenon. You brought up the subject of hijras, Navneeta. until 1871, when the British passed a special law to criminalize them called the Criminal Tribes Act. I mean, I still find that name astonishing. And that's when the language of being in public was introduced into the legal sphere in India. Because never before has there anything been said about hijras not appearing in public, should not appear in public, should be in private, about sort of sexual eroticism, only should be in private, should not be in public. I mean, that historically, it's actually very clear to see that the engine of colonialism really did a number on the streets of India in that sense, right? It just sort of rode roughshod over all these, as you said, highly permeable boundaries between what was private and what was public. And we are at such a moment today that the ideas of, even as the ideas of sex are pushed more and more into the realm of the private, which is, if we see it, we're going to criminalize it, it's commensurate or directly proportionate with the way in which the ideas of religion are getting more and more pushed into the public sphere. And as a friend of mine pointed out, those need to cross. We need to make sex more public again, and religion should be put right back in the closet and say, do what you want, but don't let me see it. Which of course is the absolute opposite direction of where we're headed in now, much to, I think, my despair.
Madhavi and Navneet, I think something that we were just discussing before the discussion started was that our viewers probably don't know that both of you, including myself, we are not lawyers. And what I found fascinating about your book was in the acknowledgement section, you write that as a non-lawyer writing a book on the law, you would have had to rely on strong legal minds to help you formulate this book. And I'm very curious to ask you, what was it like for you to engage with the law in such a critical way and yet so wonderfully explain the nuances and how some acronyms, for example, were formulated, and finding these small distinctions and mistakes with even with how some of our own judges have pronounced certain cases. What was it like for you to research and write a book like this, despite not having a legal background?
Yeah, I think actually, and all the lawyers in the audience should cover their ears, I think it was actually a huge advantage not to have a law background for some of the reasons that I said earlier, which is that I don't think of the law as a sacred cow, that I can actually approach it with a critical mind. As I think both Navneeta and I exemplify, to be a professor, and in my case, a professor of English, where the brief is, as it were, reading texts. And lest we forget, the most common mode in which law is practiced or understood around the world is the mode of interpretation, right? You interpret laws. This is why the sort of religious status or level that we accord to the law is so, so not true, because the law, depending on which judge is reading it or which lawyer is reading it, is extremely malleable, even though it pretends to be absolute and concrete and set in stone. So as someone whose entire career is based on reading texts, the law became yet another text for me to read and interpret. And because I didn't have the baggage of reverence to cloud my reading or my judgment, it was actually just an absolute pleasure and fascinating. And it's true, if you set out to write a book on laws in relation to desire, sexuality, gender, it's an immense field, absolutely immense. And so one of the things, and Navneeta, as you know, one of the ways in which I ordered my readings was to pick up on adjectives that the law itself has used in relation to sexuality. And so then I ordered my sections according to 4 of these adjectives, the first of which is criminal, which is a word often used in relation to sexuality. The second is the word immoral. In this chapter, I think about sex work, prostitution, and the way in which India is actually in a very interesting and difficult position in relation to prostitution, because it was never illegal here, but we have a lot of British accounts from the 19th century, people saying, oh my God, what kind of country is this where prostitution is legal? And then of course the British, weigh right in and work to change that. And so we have a long history where sex work is legal. Sex workers are historically among the highest taxpayers in India. But to convert that into a state of immorality actually requires a lot of legal work. So that second chapter of mine is on immoral, because that's also an adjective the law uses a lot. The third section or the third chapter that I look at is under the title of obscene. And again, Navneeta talked about this word so often, which literally and etymologically means that which cannot be seen, right? Obscene is actually something that a lot of film criticism uses as something that is off-scene, ob being the prefix of scene. And so the minute something is seen in public, on the street, almost by definition, exemplified by lower class, lower caste, religious minorities, who should not be seen, who should sort of stay quiet and better not be seen. The minute that comes into any kind of visibility, that's when the obscenity laws get rolled out. And this, of course, and I think I haven't done a study of this, but I think there's a disproportionate number of obscenity case prosecutions in relation to class, caste, and religious minorities. And I think that's no coincidence. And my fourth section is using the word unnatural, which of course is again something that we're all familiar with section 377. But I've used the term unnatural to think actually about a range of desires that the law criminalizes. So not just formally homosexuality, but also thinking about adultery and which the legal system decriminalized in the Joseph Schein case, but to think about the implications of why we even have something called adultery. What is being adulterated? What is this purity being adulterated? Which bodies get to be impure or pure? Which then also takes me on to the idea of the menstruating body and thinking about the Sabrimala judgment, which brings together so many deeply held phobias about women, about dirt, about caste, about uncleanness, about religion. And again, it's no coincidence that the Sabrimala Shrine is one of the few in India which is expressly and openly cross-religious, which is to say it is very much sort of visited by Muslims and Hindus together. And it is a shrine and temple, unlike many, many, many temples in Kerala, that has never had a history of caste bias and has always said everyone is free to enter. And I think, again, it's no coincidence that that should have become the flashpoint for this kind of, for reinforcing or bringing in through the back door, because of course the whole point is that menstruating women should not enter through the front steps, bringing in through the back door a bigotry and a phobia that was officially disallowed on these other lines, along lines of caste and religion, and they sought to reinforce it in terms of gendered bodies. And so I think about the menstruating body, I think about the homosexual man, I think about the adulterous woman, I think about the transgendered body, and the ways in which complicating the idea of transgender per force has to make us rethink a lot of our laws, including, for instance, laws on rape, which are legally understood now as being perpetrated only by men on women. Where do we fit transgender bodies within that? This is just a whole bunch of questions that opens up. The minute you undermine a solidity or a solid basis for gender, the minute you undermine a certain kind of identifiable ontological basis for sexuality. And so I am interested in undermining that because I'm deeply skeptical about monolithic juggernauts, especially legal ones, because we have seen, we don't even need to justify this, right? Anywhere we look around us, everyone is bemoaning the absolute failure of the legal system in our lives. The sort of caseload that builds up day after day, I can only imagine what the pandemic has done to that. And so this idea that the legal system is not working, I'm hoping that this book is at least the beginning of a conversation about how we might think differently about the law. And I think scholars from different fields need to contribute to this, because we need to think about the ambit of the law in multiple scenarios, in multiple fields. My interest is in sexuality and desire and gender. And so this is my approach to thinking about where the law is a flaw in relation to these subjects.
We're close to the end of the discussion, but Navneeta, I want to direct your attention to a question that we received, and I think it very closely ties to what you've just said, Madhavi. So one of the things that I really liked in the book was the wordplay, and I mentioned this at the beginning also. And whether we look at acts like Sita, or whether we look at the chapter in Unnatural, where you start by talking about Pinky Pramanik, who's a transgender person, and then move on to talk about Pinky Anand in the context of the adultery case, I found the use of language and the deployment of language very, very interesting, and also your interrogation, Madhavi. So Navneeta, we received a very interesting question in which Maitri is asking us that the law functions through language, as we have understood from the text and also from this discussion, and oftentimes sex and sexuality is outside the ambit of language or words. Again, I think this is a contention that might be that not everyone would agree with. But the question that Maitri is asking is whether the law can be written in a way that recognizes emerging queer identities and perhaps queer desires and even non-normative desires, and whether this language can be rephrased in a way that the law, our judges, our advocates can understand. So Navneeta, maybe you could take a stab at this quite a complicated question.
Yeah, that is an interesting question. Like, again, you know, it's not as if I've read so much legal judgments to actually, you know, say conclusively. But one thing I must say is that, you know, adding to what Madhi was also saying earlier, that what does it mean as a literary and cultural studies scholar to then read legal judgments, right? Like, so I teach this course called Public Formations of Sexuality in JNU. And so one time I was teaching it, I decided to teach the Navtej judgment, you know, and it was really a challenging task, I must say, because for one thing, it's huge. Like, you know, these judgments are really long, and you also see the kind of citational quality of the law, right? Like, because you are, you know, it is a very, in that sense, every judgment is sort of building on a large corpus of legal judgments, right? Like, and there one, you know, if, you know, I don't know how many of you've read the judgment, but if you go back and read it, one thing you will really notice is the way the judgment constantly pays attention to the workings of language, right? Like, so that, you know, at every point, if you have to make a statement, you also have to define what you mean by that word in that context, right? Like, so there is, in that sense, you know, in order to adjudicate, right, like what is autonomy, what is a body, what is, you know, dignity, all those categories have to be constantly rethought, you know, like there is a way in which law has to, if you are asking, like, you know, can contemporary imaginations of queerness and sexuality enter into the sphere of law? I would say it has already entered in, because many judgments actually and workings of law actually have had to deal with these questions, right? Like, say, you know, like there have been property cases, for example, in which, you know, like regarding, like, say, a hijra, you know, like a guru and chela kind of arrangement, where there've been court cases where the court has had to then say, is it the who actually can inherit, right? Like, so when you think about, you know, if you look at the large, you know, history of legal cases in the Indian context, it is not as if it has not acknowledged, even prior to, you know, reading down 377, I think the workings of law has had to engage with the fact that sexual formations are much more non-normative, actually, right? Like, so in that sense, I think it's important also to then now at this current juncture look at longer histories of judgments and to see how in the workings of law, though that there are often, that many things are often opened up also, right? Like that it's not only in that sense, it is also like a cultural form, a linguistic form, which has a lot of scope for interpretation, right? And like the language, I mean, like this is also like the way, say, educational institutions work, for example, right? Like you might have one kind of rules that are laid out, but when you think of the practices, right? Like, say, you know, for someone who did all her education in a Catholic girls' school, you know, there were many laws prohibiting lots of intimacies, right? Like, but you do know that the practices will not will never be exhausted by the laws, right? And there's a certain way in which the workings of the institution will always have to engage with these kind of excesses, the what spills over, right? And that, I think, is the case of the history of law in India too, right? And in that sense, I do think that scholars who work with language, who work with practices of interpretations, historians, anthropologists, like have much, and some of the work they're doing with law is very interesting, right? Like even some of the work with trial courts, like say Pratiksha Bakshi's work on not just the textualized judgments, but also, what happens at the level of the workings of law, like, when what categories are brought in, what is said, what is unsaid, right? What dynamics play out in court itself, like Srimati Basu's work on family courts, right? Like, so I think there's a lot that can be done to also, and there's a lot of interesting work happening, which points to this kind of, the linguistic and the interpretative workings of law, right? Like, yeah, that would be my stab at that question. Yeah, but I was also thinking that I think there was this recent, I don't know, 2-3 months ago, I think there was this incident in the Madras High Court, I think, where one judge was suggesting that there should be, do you remember that, Madhavi?
Yeah,
education. Yeah.
To bring them up to speed.
Yeah.
Absolutely. And I thought, that was wonderful. There are lots of individual judges and individual judgments that are wonderful. But I think Maitri's question actually points to perhaps something even more fundamental about the law, which is that are the auspices of the law the place where we can find justice, or where we can find a sort of a better way of life or a better way of living? And I think the denuding of, to go back to that word, the public sphere, with only the courts really standing in some cases between us and utter oppression, has led us to invest the courts and invest the law with, I think, far too much power. I think we need to work on developing, if we can, ever again, work on developing a much, much stronger public sphere, and recognizing that the law is deeply politically motivated, that whatever government you have in place is going to twist the law to suit themselves. I mean, the number of judgments you're seeing, most recently the Karnataka High Court, that is clearly flouting Article 15 and the freedom of expression. The courts can be extremely and utterly beholden to the politics of the day. And so to then say, can we find adequate representation and justice within the law, I think is a question whose optimism I wish I could share, but I don't, because I really think unless you have very strong extrajudicial machineries in place, we can't actually expect the law to be all that and to protect us in the way which we would like, protect us and everybody in the ways in which we would like.
Yeah, that is a different question. Or, if that is the level at which we are asking the question, I think, that even within sexuality politics, there is that question, right? Like many groups have also been asking, like whether the full-on investment in reading down 377, what has it allowed for? What has it, what other questions got sidelined, right? Or how did so what happens when you centralize these kind of rights and legal discourse as the engine of a political movement, right? And I think the women's movement in India also has asked that question at multiple instances.
Definitely.
Because, right? Like, because one thing we know is that laws can change, but like you have, like say, like hard and fast laws in terms of domestic violence, right? Like, but unless you rethink the structure of the family, the structure of patriarchy, like what do the laws mean, right? Like, so that I think is in some senses much more work too, right? You are getting into the inside, the intimate, it requires a lot of undoing, redoing, right? And that requires a whole array of working together, right? Like at many different levels. And I do agree, at that level, really it's misleading to think that the law will be our, obviously at the current moment we are in, we have had to, use the law whenever possible, right? But yeah, to think that that would be the savior is a very, because it is very connected to political changes, regimes, which is very evident, right? Like,
right. And that's absolutely right. I think it is much more work. We have to ask many more questions, which takes us back to that question of criticism kind of and interpretation. And we need to be, again, and I bring this back to the education system, we need to foster a level of education in which people think it's their right to ask questions, not their right to stay suppressed, or not their lot in life that they must accept to stay suppressed and not speak back to the law.
This has been a fabulous discussion. I can say that we're almost running out of time. Madhavi, I'd just like to leave you with the last word. We've had throughout this conversation, we've touched upon a lot of different topics. We've spoken about what's unnatural, what's natural. We've spoken about the public-private dichotomy. We've spoken about obscenity. We've also spoken about religion, caste, gender. We've spoken also about the role that states play in governing our lives. If there is one message that you would like to leave readers who read your book and are seeking to learn and understand more about the law, what would that one message be?
I'm so bad at one messages, Kana, and you're making this sound like my last words, as though, after this you will not hear from me any longer. But I mean, at the risk of repeating myself, I really think that the one message has to be always question. Do not assume anything, and assume nothing was one of the fundamental clarion calls of the gay movement in the US, for instance, right? Unless you keep questioning assumptions, especially official assumptions, legal assumptions, you are going to be trapped in a net that you think is natural, but its naturalness only appears so because you have not bothered to question it. And so we must all question things at every turn in the road. Otherwise, we are just going to end up on a one-way street, which I fear we already are on.
On that note, I think there's a lot for us to think about and a lot more questions that I hope more people ask of the law. Thank you so much, Madhavi, for taking out the time and speaking to us. And thank you so much, Navneeta, for joining us from Berlin. And thank you also to our sign language interpreters for very tirelessly and effortlessly reinterpreting this entire conversation. Once again, this Book Adda was brought to you by Vidhi Center for Legal Policy, and we hope all of you have a great evening ahead. Thank you so much for the audience as well, for your wonderful questions and for listening into this conversation.
Thank you, Kanav. Thank you, Navneeta.
Thanks, Preeti. Thanks, everyone.
Thanks, Maitreyi. Bye.